Hi, my name is Christopher Millard. I'm Professor of Privacy and Information Law at Queen Mary University of London, and I'm off counsel to the law firm Bristow's. I'm here today to talk to you about cloud computing, what it is, why it's important, why it raises certain legal and regulatory issues that need to be considered quite carefully. But first of all, what is cloud computing? There are many definitions out there, and you will perhaps have seen them in the press and elsewhere. And indeed, there are standards bodies working on some quite complicated descriptions of cloud computing. But for our purposes, I think it's helpful to think of the cloud and cloud computing as simply a means of delivering IT resources such as computer power, or compute as it's called in the cloud industry, and storage and other services. And these are delivered online via a network, typically the internet, and they're delivered in a way that they can be consumed or used as though they were a utility service. So you buy as much or as little as you want and need, and you pay typically on a basis of how much you use and when you use it. Very different from a traditional approach to IT resourcing. And indeed, the reference to utility is not accidental, and some are suggesting that cloud computing may end up being highly disruptive in the way that other utility services have been historically. For example, about 100 years ago, a man called Thomas Edison developed a new service, and had he been around today, I'm sure he would have called it electricity as a service, but I don't think he called it that. But he had a power station, he generated electricity, and he built an electricity grid, which was a network basically for delivering his electricity as a service. And apparently in Manhattan, which was his first main market, he had great difficulty persuading businesses, persuading factory owners, persuading government agencies and so on to use his new electricity as a service, because the typical response he would get is, well, electricity is absolutely fundamental to us in order to do our business, in order to keep the lights on, literally keep the machines running in the factory and so on. We could never trust an outside service provider to deliver something as important as electricity. And of course these organizations would have typically in their basement their own generator, their own fuel supplies, their own dedicated team of people maintaining the equipment, keeping the generators running, and so on. So I think that's potentially a very helpful analogy, because in the cloud computing industry today, many organizations, particularly if they are heavily regulated, such as financial institutions in the private sector, or if they have particular concerns about citizen data, such as government agencies, they are often saying, actually, our IT resources are so fundamental to the way we operate, we couldn't possibly trust them to an outside service provider and buy them as a utility. So if that analogy turns out to be a helpful one, I think we will find in fairly short order that most organizations have overcome their initial reservations about cloud computing, and in part at least are starting to source their IT from the cloud. But let's just look at how big the market is today and where it's going. Well, according to Forrester Research, the global market for cloud computing services is predicted to grow to about $240 billion by 2020. A recent study that was commissioned by the European Commission, actually, from IDC, has predicted the cumulative EU impact for 2015 to 2020 of the cloud as being close to €1 trillion, and involving the creation of 3.8 million new jobs. It's also predicted that by about 2016, more than half of all new IT procurement will consist of procurement of cloud services. Again, these are just projections, but if they turn out to be accurate, then cloud is indeed a highly disruptive development that will have a major impact on businesses, on governments, on consumers, on citizens. So what are the main types of cloud service? Well, again, this is a simplification. I apologize to any of you who might be technical experts in this field, but the way cloud is normally described is in terms of three types of service. First of all, the bottom layer, or the most fundamental type of service, is called infrastructure as a service, and as the name suggests, it involves physical infrastructure, the actual servers that are used to process data, and the physical equipment surrounding those servers. The next layer up is platform as a service, which is perhaps best thought of in terms of a configured server with an operating system, perhaps some security technology, anti-malware software and so on which you can run applications. And then the highest level of complexity or sophistication is software as a service, which I think is best seen as fully functioning applications that can be accessed online, such as webmail or HR management software, customer relations management software, applications for productivity software, such as Office 365, Google Apps, and so on. Maybe storage applications for backing up and synchronizing data in the cloud. There are many, many examples now of these cloud services. Now, there are some other fundamental technological issues that may be key to why cloud is having such a big impact. One is the development of virtualization and virtual machines. And again, put simply, this means that a specific physical computer or a physical server can be used simultaneously as a platform for running multiple virtual machines using software which enables virtualization to take place. So if you can imagine that instead of having a PC or a laptop on your desk, or instead of having a physical server in your IT room at the office, you have access online to a virtual PC or a virtual server, which can be shared with many other users at the same time. That's a very important point when it comes to working out the legal implications of using the cloud compared to more traditional forms of technology sourcing and some of the regulatory consequences. If we look then at the main ways in which cloud is deployed, and again, the electricity analogy may be helpful. The traditional model would be you generated all your electricity on your own premises, and the future grid model for electricity was that you source all your electricity from an external service provider as a utility service. But there are other permutations that are possible, and indeed even today, although most organizations and most individuals source almost all of their electricity from one or more suppliers via a grid, there are still circumstances where it makes sense to have your own backup generators, maybe your own backup battery storage and so on. And there are similar issues that can arise in the context of IT resources too. But if we take that analogy a little further, if you imagine in terms of the ways of deploying cloud services, you're starting from a point where people have their own IT resources on-premise with their own IT department, their own hardware and software and maintenance issues and so on. And the future might be more conceived in terms of the cloud, or more accurately, a cloud of clouds, because there are many different clouds out there in terms of infrastructure platform and software as a service. And the expectation is that more and more businesses will gradually migrate their IT services from this in-house deployment model to the public cloud, as it's called, model. But in between there are again some variations, just as there have been with electricity supply. So it's possible to have, for example, a private cloud where you can get some benefits from using this virtualization software that enables you to use IT resources much more efficiently, but it can be in a form that is secure and dedicated to a particular customer. Another possibility is to use a hybrid deployment model where you carry on using some at least of your internal resources, but you gradually use more and more of the public cloud services, and you can migrate in either direction. Another possibility is a community cloud where organizations in a particular sector with particular technical or regulatory requirements. For example, they might be part of a network in a particular industry where they have protocols and they wish to process data in a particular way, or they may be governed by similar regulations, for example, financial institutions or healthcare organizations. One model that is being looked at quite carefully at the moment is the development of community clouds, which would take into account the special requirements, whether they be commercial or technical or regulatory, of a particular community, and develop a cloud that works best in that environment. Moving on to what is actually different or special about cloud services, why should legislators, regulators, business people, lawyers and others be concerned or interested in this development? Well, the first thing I'd like to point out is that the self-service model for buying your own resources as a utility is very different to the traditional model whereby you might generate your own electricity, or in this case build your own IT infrastructure and sources. And one of the confusions I think that's around at the moment is that many organizations and quite a lot of regulators indeed see cloud as just another form of outsourcing. So they say, well, there is actually nothing special about this. Since the beginning of the computer industry, actually, people have had access remotely to other machines. In the early days of mainframe computing, they used timeshare computing. More recently, in the last couple of decades, there's been a huge growth in outsourcing services. But I think there is something fundamentally different about the cloud as a way of sourcing IT compared to outsourcing arrangements. And the main difference is, I think, to do with control and to do with the way in which the process develops. So in a traditional outsourcing arrangement, an organization would normally have its own IT resources, and it would be moving them out to an external service provider, hence the term outsourcing. And that might involve the physical transfer of assets, the legal transfer of title to assets. It might involve transfers of staff, reassignment or other arrangements to deal with software licensing and so on. But it was very much a process that starts in-house and moves out. Cloud is typically done in the opposite direction. So in the cloud, or in a cloud computing scenario, a cloud service provider will develop a particular service. It will already be up and running. It may already be available on a large scale to many customers, and then a particular customer will buy that service and it will come in to the organization. So the opposite really to outsourcing. And that has a number of important consequences in terms of contracts and in terms of regulation. So if we look first of all at the contractual side, whereas in a traditional outsourcing deal, such arrangements would typically be heavily negotiated, involving technical experts, involving risk management specialists, involving lawyers and others, who would then specify in considerable detail in a contractual form the arrangements that are envisaged, the liabilities of the parties, the fee arrangements, the change control provisions, the exit provisions, and so on. And these arrangements might well be set up to run for 5 or 7 years initially, often with extension provisions built in. Very different as a way of approaching a contract to what we find now in the cloud, where typically most cloud services are purchased off the shelf, or off the virtual shelf, I guess you could say, on a take-it-or-leave-it standardized, commoditized basis. So most people using the cloud, and this is not just consumers, this is also in the business and public sector context, most people using cloud are using services that have already been built that are available to pretty much a standard specification, and they are bought using, they're procured using standard terms of service. Now there are exceptions to that, and I'll get to them in a moment, but it does mean that from the point of view of control and responsibility and liability and regulatory accountability, cloud is very different to traditional outsourcing. And in the last couple of decades, as outsourcing has become a very common mechanism for transferring capital expenditure and assets from inside an organization to outside, and then replacing them with a service that's paid for on a payment, typically a monthly or other regular payment basis. Those deals now, I would say, many regulators, even in heavily regulated sectors like financial services, the regulators have understood how that works, and they have perhaps put in place particular safeguards and particular audit arrangements and so on, but they've become comfortable with traditional outsourcing on the whole. Cloud is a very different animal entirely, and I think at the moment we're going through a transitional phase where many regulators and others, regulators and courts in some cases, don't really understand how cloud works, and they think it's appropriate to impose similar controls on cloud computing to those that have been imposed on traditional outsourcing arrangements. Now, so overall I would say cloud is certainly a form of sourcing, but it is not normally a traditional outsourcing arrangements. So if you end up buying a cloud service as a commoditized, standardized service with non-negotiable contract clauses, what should you be watching out for? What should you expect to find if you actually do read the contract, which many people of course don't? Well, I can tell you based on empirical evidence what you're likely to find. At Queen Mary University of London in the Cloud Legal Project, we have analysed more than 30 standard sets of contractual documentation for cloud services that are available in Europe. And we found a number of things which, when we started this research in 2009, was a bit of a surprise to us actually. For example, we discovered that many popular cloud services are delivered using a quite complicated layered technology arrangement, which is not often transparent or may not be understood by a typical customer. So a lot of very popular services for webmail, for storage of data, synchronization of data and so on, may be branded in a particular way, but when you read the small print or ask a few questions, you discover that the service provider you are entering into a contract with doesn't actually have physical possession of your data, because they don't have the infrastructure that's used to provide the ultimate service. And if you can cast your mind back to the earlier discussion we had about the layered nature of cloud, with infrastructure on top of which may be built platforms, on top of which may be built software as a service, what people are finding now that they bother to ask in some cases is that the software as a service provider they thought they were entrusting their data to doesn't actually keep their data at all, but the software as a service provider has an arrangement separately with a platform or infrastructure provider which actually has your data. Now that can have some quite significant consequences, because unlike again a traditional outsourcing deal where it's not uncommon for there to be sub-contractors or sub-providers, but yet that's usually on a very transparent basis where there's a chain of control and accountability. In many cloud services, the users of the cloud service, the customers, are not aware even that behind the scenes there is a complex arrangement with subcontractors and sub-subcontractors and so on. Now that may give rise to issues in terms of contractual liability. It may also greatly complicate compliance areas such as data protection, because the traditional approach in data protection law, for example, in the 1995 EU Data Protection Directive and the national laws that have implemented that, the traditional approach is that there should always be a data controller who ultimately has responsibility for personal data. And if the data controller chooses to delegate the processing of personal data, then it must enter into a contractual arrangement with a processor, and if necessary a sub-processor, in which the data controller gives instructions. That's a key concept in most data protection laws. And the instructions have to cover the way in which the data are processed in terms of control, and they have to be specific about the security arrangements for processing the data. Now that may make sense in a traditional outsourcing scenario where the customer can specify in detail in a contract how the data are to be processed, and may even be able to specify in detail the security arrangements that are to be put in place. It does not, however, make much sense in a public cloud environment where, where there may be literally millions of customers using the same physical infrastructure on a shared basis. It doesn't really make much sense for each of them to have an obligation to impose controls on the way in which data are processed and the way in which security arrangements are made. Because of the obvious scalability issues, it's just not feasible, first of all, for an infrastructure provider such as Amazon Web Services or Microsoft or Google or any of the other very large infrastructure providers. It doesn't make sense for them to deal with all those customers on an individual basis. But also it doesn't work in terms of the regulatory objective, because if each of millions of users of a particular cloud server farm were able to give specific instructions in terms of security arrangements, perhaps they were able to individually, if they wish to, audit and check and do physical inspections of the infrastructure, then that would potentially destabilize the environment and represent, ironically, a security risk for all the other users of that particular infrastructure. This is an issue that data protection regulators on the whole are grappling with, or ignoring, I would say, in many cases, but certainly it's an issue that's not been resolved yet. In terms of these standard contract clauses, when we analysed the 31 contracts and we mapped them against 20 types of variables, so we looked at, for example, at the term of the contract, the governing law, who had liability, whether there were exclusions or limitations of liability, who was responsible for personal data, etc. When we mapped those 31 contracts against the 20 variables, we found, first of all, as I've just explained, that the contractual structure often did not really reflect or deal adequately with the complexity of the layered cloud service provision arrangement. But we also found that it was very common in these contracts, and is still today very common, for there to be sweeping exclusions of liability and limitations of liability. even to the extreme in some cases, particularly some of the contracts governed by the law of a US state, where the cloud service provider would not only say it had no responsibility whatsoever and no liability whatsoever for the customer's data, but that if anybody else was harmed and sued the provider, then the customer would indemnify the provider against such claims. That's a so-called reverse indemnity, which is a very extreme kind of provision that you would not expect to see often in a negotiated contract, and indeed is probably ineffective and unenforceable and may even be illegal under consumer protection laws in particular countries, particularly in the EU. So you find these quite extreme one-sided contracts where the provider takes the money, assuming you're paying for this service, and ends up with no responsibility, or attempts to leave itself with no responsibility. We also found clauses that said that the service may be modified, may be discontinued even, without any recourse for the customer, potentially without much or even any notice being given to the customer. That is a source of concern for particularly business and government users. And in terms of the ability to get your data back if you wish to stop using a service, or maybe the service is discontinued, we found some quite unhelpful, I would say, provisions from the point of view of customers, whereby they may find it very difficult to get back not only their raw data, but also the important metadata, or data about data, which are essential in many cases to making effective use of the data, either by transferring it to another service provider or by bringing it back in-house to process yourself. So although millions of people are using cloud services today based on these standard non-negotiable click-through agreements containing in many cases some very one-sided and unreasonable, I would say, provisions, what's happening is, as the cloud market is maturing and developing very rapidly, more of the major customers or potential customers, such as businesses and government agencies, are demanding different terms of service. So that raises the question, can you actually in practice negotiate a cloud contract? The traditional view, and this is still widely believed, I think, is that you can't, for the reasons I've given. It's a standardized, commoditized service. How could it really be negotiated? And I think that, to be fair, many cloud service providers have been very happy that that has been the assumption. Some have even said, no, we will not negotiate. This is a take it or leave it offering. It's a utility service. Just as you can't normally in a mass market utility service arrangement for electricity negotiate a different voltage or a different supply arrangement. I mean, of course there are exceptions in certain cases, but on the whole those things are just take it or leave it standard features of the service, and many of the commercial terms are also standardized. But what happens in practice, and what we're finding increasingly in our research, is that more and more cloud contracts are being negotiated. And these tend to be in cases where either the contract value is very high in cash terms, or where there is a market opportunity for a cloud provider which, although the first deal may not be that substantial, is seen as a potential opportunity to get into a very large market. So in fact, major cloud vendors, all of them do now, based on our research, negotiate cloud contracts in particular cases. Now, these one-off contracts tend to be confidential, which makes it a little difficult to do research in this area, although in the public sector, thanks to freedom of information laws, it is increasingly possible to get access to negotiated cloud contracts. And again, in the Cloud Legal Project at Queen Mary University of London, we have conducted an extensive study into negotiated cloud contract arrangements, and we've done that by talking to cloud providers, to cloud customers, to intermediaries who repackage and resell cloud services, to others involved in the cloud procurement chain, such as the insurance industry, such as lawyers who've negotiated cloud deals. And we've also done a lot of freedom of information requests to find out what's happening in the public sector. And when we put all of that research together and analysed it, it very clearly emerged that there are a few areas that tend to be the most heavily negotiated and that are most likely to be deal breakers and reasons why prospective customers will walk away from a cloud deal. And I just want to talk about the top 5 from our research findings. The first one, perhaps not surprisingly, involves exclusions and limitations of liability. The kind of extreme one-sided exclusion clauses I described that you find in many standard click-through cloud agreements are just not acceptable to major customers whether they be in the private sector or the public sector. And those are negotiated. And they're negotiated in various ways in terms of maybe caps on liability being changed, certain things not being excluded, compensation arrangements perhaps where there are breaches. There are various commercial and other changes that can be made to such clauses. The second thing that tends to be negotiated, at least initially in deals, is service levels, where traditionally, say in an outsourcing deal, the customer would be able to specify and gain agreement in great detail on the exact service to be provided in terms of availability and reliability and uptime and so on. Many customers, major customers, go into cloud negotiations with the intention or the expectation indeed that they will be able to specify service levels in a similar way. Now, for the reasons I explained earlier, that doesn't always make sense. Indeed, it often doesn't make sense beyond a certain point. And secondly, what customers are tending to find, or prospective customers are finding, when they do their due diligence and they actually get audit reports and they examine the service and they try it out perhaps on a pilot basis, they discover that many cloud services way exceed in terms of service levels the service that the customer has been able to provide itself internally or that it has previously sourced from an external service provider. And so it's not uncommon now in terms of, say, cloud infrastructure availability to see statistics at 99.99 and then several further nines after that percentage availability, which is very difficult to achieve in terms of an in-house IT resource. So we found SLAs, service level agreements, are initially on the table as an important negotiating point. Quite often they become less significant as negotiations progress. The third area that tends to be heavily negotiated and is in some cases a deal breaker is the whole area of security and privacy. And specifically in Europe, that tends to involve quite detailed discussions about the compliance with national data protection laws. As I said earlier, the way in which personal data are regulated and protected under EU national data protection laws is that a controller has primary responsibility, and if the controller wishes to delegate processing to a processor, then a contract has to be put in place that deals with control and security. And so a starting point again in many of these negotiations is that that has to be put in place in a cloud arrangement and potentially right down the chain in a multi-layered complex service provision environment where there may be one party providing software as a service but then relying in part on other parties who provide platform as a service or infrastructure as a service and so on. And for the reasons I explained earlier in this presentation, that could be really very difficult or actually impossible in practice. There are other fundamental issues to do with data protection, right down to the conceptual level of what is personal data when it's being processed in a complex cloud ecosystem, who is responsible for the data, which national laws apply, and it's possible that there may be many laws applying simultaneously. How do things like data export controls work when data may be transferred between data centers in different jurisdictions, potentially including transfers to countries outside the EEA which don't have an adequate level of protection for personal data. And this is a very complex field in itself, and I'm not going to go into detail now, but just taking the first of those, what is regulated as personal data? Given the way in which data may be handled by different participants in a cloud ecosystem, I don't think it makes sense anymore to assume that if I as a customer have personal data, it could be about employees, it could be about customers, or whatever, and I transfer it to a cloud provider who transfers it to another cloud provider and so on down the chain. I think it's possible that in the hands of some of those other actors, it doesn't make sense anymore to treat that as personal data. For example, a provider of a pure infrastructure service, which is providing in effect a virtual machine on which I or an intermediary cloud provider can process data, that infrastructure provider may have neither knowledge nor control over what is done with that virtual machine. So they may not even know whether there is any personal data on a virtual machine at a particular time, nor what it is being processed for, even what the security arrangements are, because I, as the customer or one of my intermediary suppliers, may control encryption and access controls and so on. These are fundamental issues that challenge the very basic way in which data protection law and regulation works. And sadly, they are not issues that many regulators have been willing to grapple with yet in terms of when data is in a form that it should be regulated and who should be responsible in terms of the controller processor paradigm. And I also regret to say that the current proposals to reform EU data protection law, particularly the proposed General Data Protection Regulation, would not really help in this area in terms of clarifying responsibilities and allocating them in a meaningful way. So moving on briefly to the fourth and fifth of the top 5 issues that get negotiated, the fourth one is lock-in and exit. So if a major customer, again private sector or public sector, becomes dependent on using a particular cloud infrastructure or platform or software as a service offering, they may find it increasingly difficult to get out of that arrangement, move to another service provider. And that may be for a number of reasons. It may be to do with specific features that only one provider is offering, but often it's to do with more technical questions about data and metadata and how they might be moved from one platform or service to another. And these increasingly are being negotiated in major cloud contracts. And then the fifth topic that is a very hot topic in negotiation is the provider's ability to change either features of the service or contract terms on a unilateral basis, often at very short notice or even potentially no notice. Now, in the standardized, commoditized, take it or leave it model, then most people accept that. Occasionally there are disputes, occasionally regulators intervene, but on the whole, these unilateral variation provisions are accepted, or they just happen in practice. In a negotiated deal for a very high value or mission critical cloud arrangement, that just may not be good enough. And what we're finding is that cloud providers are usually holding on very strongly to the assertion that they have to have the right to change the service because they're providing it sometimes to millions of customers, and they cannot negotiate individually with every customer every time they want to make a technical or commercial change. But the compromise that may be reached is that a particular high-value customer or a customer that for regulatory reasons has to have more information, it's possible that a cloud provider may provide greater notice, it may provide more detail, it may even agree that a particular customer has a right to terminate an agreement, to move the data, maybe even to get compensation if they can't live with and they cannot accommodate a particular change that is proposed. But as I say, for operational reasons, not surprisingly, cloud providers, particularly at the infrastructure and platform level, are unlikely to agree that specific individual customers in what's called a multi-tenant cloud environment, that means where lots of other people are also using the same service, they're unlikely to agree that a particular customer can veto a change or have direct control over the way in which the service evolves. So that's a very quick overview of what cloud computing is, why it might be disruptive commercially and technically and in regulatory and legal terms, and some of the specific challenges that are currently being faced in terms of cloud contracts and data protection in the cloud. So I'd like to thank you very much for listening. If you want to know more about this, I would encourage you to visit the Cloud Legal Project website, where we have a number of materials available for free download. And I would also like to recommend a book that I've recently co-authored and edited working with colleagues from that Cloud Legal Project. It's called Cloud Computing Law. It's available from Amazon, it's available direct from Oxford University Press, and you can buy it as a printed book or as an e-book, including a Kindle edition. And I hope you would find that useful if you want to go into these issues in more detail. But for now, the last thing I'd like to say is I always like to finish a talk about the cloud with a weather forecast, or at least a cloud forecast. And I would say that the cloud industry and cloud computing, they are here to stay. The market is evolving very fast in technical and commercial and scale terms, so this is not going to go away. Some of the traditional approaches in law and regulation to the way in which personal data are processed, the way in which IT resources are managed, don't work very well in the cloud. And I think it's going to take, my forecast would be, it's going to take some time for legislators and regulators to come to terms with that, and indeed the courts as well. But that change will happen. Cloud is here to stay, and we are all going to end up adapting in various ways to the way in which cloud computing services are provided. That doesn't mean there won't be bumps on the road. There will almost certainly be disputes. There will be arguments about responsibility, particularly for personal data. But gradually, and maybe quite quickly, we will see contract terms evolving to be less one-sided, perhaps less unreasonable for the standard contracts. We will see people becoming more comfortable with negotiating cloud contracts. We will see regulators understanding in a deeper way what is distinctive about the cloud and who can, in a meaningful way, be given responsibility for managing data in clouds that are regulated, whether it's by financial services or data protection or other types of regulation. So that's a very quick introduction. I hope you found it helpful, and I would encourage you to watch this space, keep an eye out for developments in the cloud, and thank you very much indeed for watching this presentation. Goodbye for now.